Okay, let's get started. Welcome to the deep dive. We sift through the sources so you don't have to. Today, we're tackling a specific bit of law, private nuisance. Now, stay with us on this one, because it might sound a bit dry, but our sources show it's actually, well, surprisingly powerful. It's been used for all sorts, from protecting gardens to, believe it or not, cleaning up whole rivers.
Absolutely. And what's really interesting is how this, quite old common law concept rooted in property rights has taken on this really significant environmental angle over the years. It often filled the gaps, didn't it, before we had all the formal regulations we have now.
Right. So our mission here is to unpack what private nuisance actually is, using the material we've got. We want to see how it works, what its limits are, and why it's still cropping up today with modern environmental issues you might read about.
Yeah, I mean, think about it from your own perspective. Maybe a neighbor's making constant noise, or there are strange smells drifting over, maybe even dust. That kind of localized conflict, that's the essence of private nuisance.
That's the classic picture, yeah, the neighborly dispute. But the kicker, like you said, and what our sources really bring out, is how that same legal idea connects up to, well, much bigger things. We're talking polluted rivers, industrial emissions covering a whole area, maybe even stuff happening underground from, say, fracking. It scales up.
Exactly. At its core, private nuisance is basically a legal challenge against someone for unlawfully interfering with how you use or enjoy your land. And to make that stick, as a claimant, you need to prove three main things based on what we're looking at.
Okay, three things. What are they? Let's break them down.
First, you need standing, and this is, well, absolutely key. It means you have to have a proper legal interest, a proprietary interest in the land that's being affected. So typically you own it or you're a tenant with exclusive possession.
Got it. So you need that solid connection to the land itself, a legal stake, basically. What's number two?
Second, there has to be an unlawful interference coming from the defendant's land. And unlawful here doesn't mean criminal, necessarily. It just means the law sees it as an infringement on your right to enjoy your property. And crucially, it has to be coming from the defendant's land or activities they control there.
Okay, so the problem's got to be traceable back to them, and it's messing with your property rights. Makes sense. And the third piece.
The third thing is that the interference needs to be substantial and unreasonable. It can't just be, a trivial annoyance or something that happens once in a blue moon. Courts look at things like how bad it is, how long it goes on for, what the nature of the area is like. Basically, would a normal person put up with this?
And what sort of interference are we talking about? The sources seem to split it into a couple of types.
They do, yeah. One is straightforward physical damage to your land or property. Think of the old case, St. Helen's Smelting Cove v. Tipping. Fumes from a smelter physically damage the claimant's trees and shrubs. That's tangible harm.
Right, actual physical damage to your stuff. What's the other category?
The other is interference with your comfort or convenience, sometimes called amenity value. This is more about things that make using your land unpleasant or difficult. So persistent noise, bad smells, excessive dust, vibrations, that kind of thing. The Hunter v. Canary Wharf case is a big one here.
Ah, yes, the TV reception case. But Hunter also drew a really important line in the sand, didn't it? What is private nuisance not supposed to be used for?
Exactly. Lord Lloyd in that case was very clear. Private nuisance protects rights related to land. It's about damage to the land or stopping you from enjoying the amenity of the land. It's not for claiming compensation for personal injuries you might suffer while you happen to be on that land, even if the defendant caused them. Unless, maybe, the injury is a direct result of the land damage itself.
Okay, that's a critical distinction. So if pollution makes you sick, you probably can't use nuisance unless that pollution also damaged your property in some way that led to the sickness. It's tied tightly to the land.
Literally.
So how did this law, which seems very focused on individual property squabbles, end up getting involved in these, well, much larger environmental battles?
Well, that's where its history becomes so relevant. Even though it's about protecting private land rights, historically it turned out to be a surprisingly effective tool against pollution. Think industrial smoke, sewage in rivers, nasty smells from factories. People used nuisance claims to fight them.
And there's that quote in the source material that really hits this home.
Yeah, Gertie wrote back in 1989 something like, "There is nothing better in the common law for getting sewage out of rivers or cleansing the atmosphere." That really tells you how powerful it was seen, especially, before specific environmental laws were widespread. It acted like a kind of early regulation.
So is plugging a gap, but also actively forcing change when maybe government action was slow or non-existent?
That's the picture, yes. For a long time, It was the main way individuals could challenge pollution affecting their property, no matter how widespread that pollution might be.
Okay, so let's say someone is causing what seems like a nuisance. Can they argue they have a right to do it? Are there defenses?
Yes, the sources lay out three main defenses a defendant might try to use. First up is prescription.
Prescription, how does that work here? Sounds like medicine.
No.
Yeah.
It's about time, essentially.
Yeah.
If the activity causing the nuisance, say, noise from a racetrack, or maybe smells from a farm, has been going on continuously and openly for 20 years, and the claimant, or the previous owners of their land, knew about it but didn't sue, the defendant might argue they've effectively gained a right to continue it. The Coventry v. Lawrence case involving the racetrack noise really dug into how this could work. It's possible to gain a right, even to make noise, through long use.
20 years is a long time to put up with something without complaining legally.
Yep.
Okay, what's the second defense?
Second is statutory authority. Right. Basically, if Parliament has passed a law specifically allowing the activity that's causing the nuisance, and the defendant is carrying out that activity properly without being negligent, then they might be off the hook. The sources mention things like the Infrastructure Act 2015, which could cover fracking, or the Civil Aviation Act for aircraft noise.
So if a law explicitly says you can do this and they're doing it by the book, that might override a nuisance claim.
It might, yes, but it's interpreted quite strictly. The law usually has to imply that the nuisance is an unavoidable consequence of doing the authorized activity. If they could have done it without causing the nuisance, the defense might not work.
Right. And the third one, this feels really relevant today with all the building and development going on.
It is. The third defense point is about planning permission. And this is, well, it's a really important takeaway for listeners. Getting planning permission from a local council to do something. It does not automatically mean it's okay to cause a nuisance.
Hold on. So even if the council approved, say, a new factory or a pig farm next door, that doesn't stop you suing for the noise or the smell if it becomes a nuisance.
Correct. Planning permission deals with public interest, zoning, development control. It's a public law thing. It doesn't cancel out your private property rights. The Wheeler v. J.J. Saunders case is the classic example. They got permission for more pigs, but the neighbors still successfully sued over the increased smell. And Coventry v. Lawrence confirmed this principle again.
That's huge. Okay, so planning permission isn't a get-out-of-jail-free card for nuisance. Good to know. So if you do prove nuisance and the defenses don't work, what can a court actually do about it? What are the remedies?
Right. The sources outline three main remedies. The big one, especially environmentally, is often the injunction. This is basically a court order telling the defendant either to stop doing something or sometimes to do something specific. It's also discretionary. The judge decides based on the situation.
What kinds of injunctions are there?
Well, you've got a prohibitory injunction that orders them to stop the nuisance activity. Stop the noise, limit the emissions, whatever it is. Then there's a mandatory injunction. This makes them take positive action, like cleaning up pollution they've caused or removing something problematic.
And the sources mention one more type, quia timet. Sounds like it means because he fears.
Exactly. The quia timet injunction is forward-looking. It's granted to prevent harm that's about to happen or is very likely to happen, but hasn't fully occurred yet. It's incredibly useful for stopping potential environmental damage before it starts. But because you're asking the court to act preemptively, the bar is quite high. You generally need to show a really strong probability of imminent and substantial, maybe even irreparable harm, and that waiting to sue later wouldn't be good enough. The old Imperial Gaslight case is an example stopping emissions that would damage a garden.
Okay, so injunctions aim to stop the problem, either now or in the future. What about compensation for damage already done?
That's the second remedy, damages. Good old monetary compensation for the loss the claimant has suffered because of the nuisance up to that point. Now, sometimes, and this is where it gets a bit controversial, courts might award damages instead of an injunction, effectively allowing the nuisance to continue but making the defendant pay for it. The Shelfer case back in 1895 laid out some criteria for when this might be okay.
What were those criteria? When might money be seen as enough?
Broadly, if the injury to the claimant's rights is small, if it can easily be estimated in money, if money is adequate compensation, and if granting an injunction would be really oppressive to the defendant, all four usually need to apply.
And the sources mention a case where this was maybe stretched a bit.
Yeah, Miller v. Jackson, the cricket ball case. Cricket balls kept landing in someone's garden. Definitely a nuisance. But the court awarded damages instead of stopping the cricket club playing there. Part of the reasoning involved the public interest in cricket. It was later criticized for, perhaps not sticking rigidly to those shelfer rules and seeming to let the club buy the right to continue the nuisance, which touches on some broader fairness issues we'll get to.
Interesting. So the court sometimes balances things, maybe controversially. What's the third remedy? This one sounds a bit more hands-on.
That's abatement. It's a self-help remedy. Basically, the person affected by the nuisance takes reasonable steps to stop it themselves. The classic example is cutting back branches from your neighbor's tree that overhang your property and cause problems.
But you'd have to be careful doing that, right?
Absolutely. The sources warn that courts are cautious about abatement. You have to do it without trespassing, if possible, and without causing unnecessary damage.
Yeah.
Get it wrong, and you could end up facing your own legal claim, or even criminal damage charges, like in the Burton v. Winters case. Generally, getting a court order is much safer.
Definitely sounds like the safer bet. Okay, we've got the concepts, defenses, remedies. Let's talk impact. Our sources flag a really old case as a major environmental win using nuisance law. Attorney General v. Birmingham Corporation, 1858.
Yes, this is a fantastic example of the law's power back then. Birmingham was growing rapidly, and like many cities, it was just pouring raw sewage straight into the local river, the River Tame. A landowner downstream, Mr. Adderley, whose property bordered the river, sued the city corporation for private nuisances because of the pollution affecting his land.
Just one landowner took on the whole city. Over sewage. What happened?
He won. The court granted a major injunction against Birmingham Corporation. This wasn't a quick fix. It effectively forced the city, over time, to completely rethink and rebuild its sewage system to stop polluting the Tame.
Wow. So a private lawsuit, fundamentally about protecting one person's property rights, forced massive public infrastructure changes for environmental benefit.
Precisely. Ben Ponton, an academic mentioned in the sources, called it a radical overhaul of sewage infrastructure. It showed how powerful private nuisance could be in driving systemic change when maybe public bodies weren't acting. It set a huge precedent.
That really drives home the point. These aren't just dusty old laws.
Okay, sticking with land rights, the sources also touch on something else. What happens when the interference goes underground?
Right, this brings up that old Latin maxim. Cuius solum eis estuus ad caelum et ad inferos.
Which means
Whoever owns the soil owns it up to the heavens and down to the depths. Or sometimes translated as down to hell.
Okay, a bit dramatic. Does the down to the depths part still hold up? Well, the up to the heavens bit is obviously limited by things like air travel rights now. But the down to the depths part, yes, it's still relevant. The Bocardo v. Star Energy case from 2010 really confirmed this for the modern era.
What was the issue in Bocardo?
Star Energy was drilling for oil, and their wells went diagonally deep underground, passing beneath land owned by Bocardo, although they never actually set foot on Bocardo's surface land. The Supreme Court said, yep, that's still trespass. Going under someone's land without permission, even deep down, interferes with their property rights.
That's significant. And the connection to modern environmental issues.
Well, the sources make the link clear. This precedent is really important when you think about things like fracking, which involves drilling and injecting fluids deep underground, or carbon capture and storage, geothermal energy projects, even just contamination spreading underground. It establishes that your property rights extend downwards, and uninvited underground intrusion can be grounds for a legal challenge, like trespass.
Okay, let's try and weave these threads together. The sources give us a hypothetical. Astrid and Jonas versus hydrofrack. Fracking contamination. How would nuisance law apply here?
Right, let's walk through it. So hydrofrack's activities have contaminated the groundwater, affecting Astrid's land crops, livestock. Jonas also lives or works there, but doesn't own or lease.
First hurdle, standing. Who can sue?
Based on what we've discussed, only Astrid has standing for a private nuisance claim. She owns the land, she has the proprietary interest. Jonas, even if he suffers loss, say, from sick livestock he manages, probably can't sue in private nuisances because he doesn't have that ownership or tenancy stake. It really highlights that limitation again.
A stark reminder. Okay, so Astrid can potentially sue. What about the interference itself?
The contaminated water affecting her land, crops, livestock, that absolutely sounds like substantial and unreasonable interference. It's physical damage, like in St. Helens, and likely affects her use and enjoyment too. Actionable nuisance.
So assuming she proves nuisance, what actions or remedies could Astrid seek against hydrofrack based on our discussion?
Well, she could definitely seek damages for the harm already done, the value of lost crops, sick animals, maybe remediation costs for the land. She could also seek an injunction, Maybe a prohibitory one to stop further fracking operations that could cause more harm, or even a quia timet injunction if there's proof of imminent future contamination risk. And given the underground nature of fracking, she might also have a claim for trespass, based on that Bocardo principle, for the physical intrusion beneath her land.
Right, so nuisance and trespass could potentially work together here, covering different aspects of the harm.
Exactly. Gives her multiple legal angles to potentially pursue.
Thinking about those remedies, especially injunctions stopping future harm, one source frames nuisance law through different ideas of justice.
Yes, that's a useful way to look at it. Thinking about corrective justice versus preventative justice. Corrective justice is backward-looking. The wrongdoer has to fix the harm they've already caused. Damages and nuisance fit this, compensating for past losses.
And preventative.
Preventative justice is forward-looking. It's about stopping the harm before it happens, or stopping ongoing harm. That's where injunctions, especially the quia timet ones, come in. They allow the court to step in and prevent the damage, which aligns with that preventative idea.
So nuisance law kind of offers both, a way to get compensated for the past and potentially stop future harm.
It does, yes.
Yeah.
And arguably, particularly in environmental contexts where damage can be irreversible or very hard to clean up, that preventative aspect, the ability to get an injunction to stop the pollution, is often the most valuable part. Stopping the harm is usually better than just getting money afterwards.
We've painted a picture of nuisance as quite a potent tool, historically and even now. But the sources are also careful to point out it's not perfect. There are criticisms, particularly around fairness and justice.
Yes, and that's crucial context. The material brings in critiques, like from Porter, linking nuisance law's limitations to broader issues of environmental justice. The idea that environmental laws and their enforcement should be fair to everyone, regardless of their background or where they live.
So what are the specific criticisms leveled at private nuisance from that perspective?
One major one is the locality rule. Remember how courts consider the character of the neighborhood when deciding if something is unreasonable. The criticism is that this can mean courts effectively tolerate more pollution or noise in poorer industrial areas because it's deemed normal for that locality. So people living there might suffer worse conditions but find it harder to win a nuisance claim than someone in a leafy suburb facing less interference. It can bake in inequality.
So the standard of what's acceptable harm can shift based on where you live, potentially disadvantaging communities already dealing with more pollution.
That's the argument, yeah. Then there's standing, which we keep coming back to. As we saw with After and Jonas, you need that proprietary interest. This automatically excludes huge numbers of people directly affected by environmental problems, renters not on the lease, children, community groups fighting for shared spaces, even if their health or quality of life is seriously impacted. They simply can't use this tool.
So often the people most exposed or vulnerable might be the least able to use this particular legal avenue.
That's key environmental justice critique. And the third point often raised relates back to remedies, specifically damages instead of injunctions. If courts choose to just award damages, like the controversial Miller v. Jackson decision seemed to suggest could happen, it can feel like the polluter is just paying a fee to continue harming the community.
A license to pollute, effectively, if they can afford the damages.
Exactly, rather than forcing them to stop the harmful activity with an injunction. This can leave communities, especially less powerful ones, exposed to ongoing harm if the defendant just sees damages as a cost of doing business. So these critiques together suggest that while nuisance has been useful, its very structure, tied to individual land ownership, might inherently limit its ability to deliver truly broad and equitable environmental justice for everyone affected.
That definitely adds important nuance and perspective. Okay, let's try and wrap this up. If you had to summarize the key takeaway from this deep dive into private nuisance, what would it be?
I'd say private nuisance is this really adaptable, long-standing common law principle. It started by protecting individual landowners, sure, but history shows it's had these significant knock-on benefits for wider communities and the environment, especially against pollution.
But it's not a silver bullet.
Definitely not. It has real limitations. Who can sue is a big one, that locality issue, and the fact that remedies like injunctions aren't guaranteed. Judicial discretion plays a huge role. However, it still offers pathways for both corrective justice through damages and, crucially, preventative justice through injunctions.
And still relevant for today's problems.
Absolutely. For anyone listening who's interested in environmental law or community action, understanding nuisance is still important. Issues like local industrial pollution, fracking impacts, air and water quality challenges, nuisance law can still be part of the conversation. And that power to get an injunction, to actually stop or prevent harm, that's often where its real value lies environmentally, maybe more so than just money after the fact. It's a living tool, not just a historical curiosity.
A tool forged in the past, but still relevant for today's challenges. Great summary. Thanks for joining us on this deep dive.
My pleasure. And maybe one final thought for you, the listener, to mull over, picking up on those critiques. Given those limitations we talked about, especially standing only for property owners, and the potential unfairness of the locality rule, can private nuisance, as it stands, really deliver environmental justice fairly for everyone hit by pollution? Or is it fundamentally weighted towards those who own land?
A really important question about who the law serves best. Keep thinking about these connections between old laws and new problems. We'll see you on the next deep dive.